Welcome. This is the Domain Name Law Show. We're here every Tuesday, noon Pacific, 3 p.m. Eastern. I'm your host, Todd Ryan. There's actually two more hosts as well. My co-hosts, Jeff Neuman and David Michaels. I'd like to start off by saying hi to those guys. Hey, Jeff, how's everything going today?
Everything's great. Yeah, just really busy. Lots of things going on. The ICANN schedule for the next ICANN meeting at the end of October is out. Um, yeah, it's busy.
Yep, we got a tight schedule today for those listening. We're going to be going 60 minutes today. Normally we go 60 to 90. You guys know how it goes. Today we're going to stick to a tight schedule, 60 minutes. We got three interesting UDRP cases to cover. Hey, David, how's everything going with you today?
Good. Quite busy actually too. I've got just finished off writing a response for USPTO office action regarding a descriptive or merely descriptive mark. It's uh, it's actually fun doing that. How to get around examiners' objections to merely descriptiveness.
You
Great.
have an interesting definition of fun.
I'm gonna put that in the notes so we can touch on that next week, talking about applying for a descriptive mark with the USPTO. Today, a couple topics. Well, you guys want to follow along, you can go to dnlshow.com/outline. You can see what we're going to cover today. There were a few things not on the outline I wanted to touch on. The first was about LTOs. And just to get into it real fast, like I said, we are going to stick to an hour today. Okay, so when you're leasing a name, or what I'm saying, you're offering a name to lease, because in here there's a bunch of domain investors trying to sell domain names. So if you're selling a name and you're offering it on an LTO, a lease to own, you can run into some risks by doing that. You can also run into risks buying it on an LTO. Wanted to talk briefly about the risks selling on an LTO. And most of the platforms that you sell on, whether it's Afternic, Spaceship, or I don't know if you know what options Dyna has, but and escrow.com. But I have a few notes of risks that people take. But first, I'll go with you, Jeff. What comes to the top of your mind when you think someone's selling a name, they offer it on an LTO? What risks does the domain owner take by doing that?
Yeah, so we talked about this a couple times. I think the biggest risk for the domain owner is losing control of the name, which could be used in an improper, illegal, infringing manner. And at that point, they risk the domain name being transferred to whoever is the complaining party for whatever reason. So, there's a risk there. And so I think, it's important that the lease agreements certainly have provisions that provide a complete acceleration of the terms if a case were to be filed, to make sure that the owner gets paid for the name, or that the well, not even that the name reverts back to the owner, because at that point the owner is not going to want to take on the legal liability of what happened, by the leasee, of the name. So yeah, I mean, that's the risk. Other than the normal business risks of not getting paid, or default, things like that.
Yeah, David, how do you see? What do you see the major risks are leasing a name?
So if it's a small sale, like say it's a $3,000 sale and you're leasing it over 36 months, you're dragging it out, but the name is only worth maybe wholesale $100. So it's not a huge risk unless you really wanted that name, or there was much more potential for it, or it was underpriced. But if it's a bigger name, like if it's worth $10,000 plus, then you really got to make sure that you have terms and conditions as to the usage of the name. You have to be able to have an ability to stop and take back the name if it's being used improperly or in an infringing way. Improperly could easily mean violating FDA laws, like say they're advertising supplements and the supplements are subject to an FDA action. That's a problem. Or if there's an FTC action for running an e-commerce site and not shipping goods. So you could be held liable for that. So you really need to know what's going on with your names.
Yeah, I think the two biggest risks are, you guys touched on one, just misuse of the name. And people, you'll hear people in the domain space say, well, seldom happens. We lease names. If they don't pay, we get the name back. So no harm, no foul. But absolutely, someone could do something illegal with the name, offer some product that's illegal or a service they're not supposed to be offering in a certain area. But the point is, it's going to happen, and it has happened. We just don't see it happen frequently. Secondly, the biggest risk is, yeah, if someone files a UDRP against the domain name, you're responsible. The domain owner's responsible. And we're seeing that now. But it's only because lease to owns are popular. It's going to help you sell your name. You don't have a lease to own on it. All the marketplaces say offering an LTO makes your name more attractive, and it certainly does. The risks to a lessee. So if you're leasing a name, I would say you just have to look at the terms, because someone could change terms of a lease and then you've spent your money branding on that name and it gets pulled out from under you, or you've done work building sites or SEO. But I don't. I'd have to give that some more thought. Maybe we'll revisit that. But can you guys think of any risks that a lessee takes by leasing a name? Because it seems pretty, fantastic to be able to put very little money down. You have control of the name, and usually there's not a lot of interest, that you're paying on the name. Sometimes it's no interest. So can you guys think of any risks that a lessee takes?
Well, if it was Epic being the intermediary, they could lose control of the name after making a whole lot of payments. So that could be a problem. The other reason might be, oh, well, this dispute is not legitimate, and it's really meant to disrupt our business, and that's a problem. So, like, say you're selling a blender bottle with a spring inside that shakes your creatine, and it happens to be subject to a takedown request, and like all of a sudden you get notified about this takedown through your registrar. That might not be legitimate. In fact, there's an active case right now where there is a USPTO TTAB cancellation proceeding based on those exact facts.
Can you think of anything, Joe?
I think it depends on how long the lease is. I mean, there's always the risk because you don't own it, that it's not a clean chain of title. But and certainly that it would depend on what the terms of the lease are and how stringent it is and what you can and can't do. But I look at that as, it's no different leasing real property. And so the risks for the leasee are, I think, less so long as the leasee maintains the true control of the domain name.
I think for next week, I'm going to look at some of the terms of service, some of the leasing agreements that are connected to each of the marketplaces that offer LTOs. And then also there was an interesting post. I say interesting. John Berryhill is, really tough on a lot of folks in this space. And what I mean by that is Domora, for example. That's a company that's going to start offering, I think it's Free Name, is offering this product called Domora that is fractionalizing names and letting people invest in names for like as little as $1. And John made a comment, I believe it was here on X, could have been on LinkedIn, where he said, great, so now people can, put like $1 down on a car, and bottom line is they really don't have any rights to it. And he made it seem like the owner could just, do what they want with it. Maybe you really can't. It's not a great investment to invest in a fractionalized name, is where he came to. But I'm going to have to take a closer look. What really caught my attention more was his comment on D3 is fractionalizing names, very similar to what Domora is doing. They're tokenizing names and they're offering fractional ownership. Well, John said there was apparently Labubu. Okay, I just remembered that because I was thinking I love Yogi Bear and it reminds me of Boo Boo. Okay, so Labubu is a brand, and apparently there's a Labubu RIP was the domain name, LABUBURIP.com, that was being fractionalized on D3. For some reason, it caught John's attention, and John said, "Oh, so I guess we're going to see the first UDRP of a fractionalized name, because apparently Labubu is trademarked. He doesn't believe that this company that owned the name that was fractionalizing it was the owner of the mark. So he stepped in and said, so it's not going to take us long to see a UDRP on a tokenized name or a fractionalized name. So those are developing stories. I'll take a closer look and we'll talk about those next week. Before we get to our outline real fast, there was one other thing I wanted to bring up. So a colleague brought up that he has a fourletter.com. I know it sounds like me since I own so many four-letter, but it's a friend, and said, what risk do I run by contacting a company that has the these four letters as their ticker symbol? And I remember selling TXRH for 8,800 to, I believe it was Texas Roadhouse, which was their symbol. Now, they reached out to me, and it was a name I had for years. Always got inquiries. I always thought it was from them because TXRH, and I thought, when you search those letters, that's what would come up. It was their ticker, and they also had it all over their website, more as an abbreviation for their company, not just a ticker. Because I will say, I've had a lot of four letters, hardly sell any ticker to any companies that want to use them for ticker symbols. But people, I hear domainers often comment, oh, that's their ticker symbol, that four letter. But getting to my colleague's question, what risk do they take by reaching out to a company that uses that as their ticker symbol? Would you guys recommend, is it okay to reach out to them? If they do, what should they do to try to protect themselves? And should they wait if they just picked up the name? Does that matter that they're reaching out to someone that may have that as their ticker symbol? Any comments, guys?
Well, ticker symbols in and of themselves are not protectable as trademarks, but unless they're being used in some sort of commercial way. So the mere fact that it's on, a stock exchange does not give trademark rights to that four letters. But that said, some companies do use their four-letter or three-letter designation as a trademark. They use it for purposes not just for the listing of the company. That said, uh, it, it's always a risk when you're reaching out to a trademark owner that they'll end up fighting you on it. Um, or even if it's not a trademark owner, they'll end up fighting you on it. Uh, if that, I certainly wouldn't reach out to them right after you register the name. But if it's something you've held on to for a while, and you know that the risk is, um, or you deem the risk to be less than if you had just registered it, then okay, maybe. But I always tend to avoid or never really recommend direct reach out to a specific buyer.
The other answer is to do your homework, develop a list of potential buyers who would likely want to have that name, and not just the ticket symbol or ticker symbol holder. And also check for trademarks. See if they actually are using it as a trademark. If they're not, then it's safer. But if they are, then definitely it's a problem. So unless it's like a common word, unless you're not going to get Ford.com anytime soon. So forget about that one. But avoid any four letters that are famous marks.
For example, if there's like GRXM, okay, Just say it happens to be a ticker symbol of somebody. Well, if you just picked it up, you would want to contact the company that has hey, and say something really silly like, hey, I just acquired this name. I can see it's your ticker symbol. Do you want it for $5,000? Now, you may have picked it up not even knowing it was their ticker symbol. In most cases, you probably didn't. So that's always important to have for your set of facts if somebody does come after you to say, hey, when I picked up this name, I didn't know that it was someone's ticker symbol. And many times you don't even know if it was their trademark. So you certainly do have rights. But what a lot of our attorneys on stage have said, and some other friends of the show always say, when you're reaching out to a company that owns a trademark and you're selling them a name that you believe it may include their trademark or this is close, you would want to say, I have this name. You're one of many entities that I believe could benefit or might be interested in this. And not, always saying they'll benefit from it. People always use that, how you want to word it. But anyway, saying there's several companies that I'm reaching out to that I think might want this name. You're one of them. If you have any interest, let me know. Basically, to let them know that you are reaching out. And like David said, do research and find out other companies that, and if it's a 4-letter, you can always, the first 2 letters, find out companies that are using the first 2 letters. They might be using, GX pharmaceutical company. And even though you don't have GXPC, which is, they still may be interested in, that, you have GXRD or something, research and development. The point is, many times it might be on the top of their mind that we want a shorter domain name, and it might only be the first couple letters or the first 3 letters in a 4-letter name. What companies are using these first 3 letters? Then, of course, you might find them using the first 3 letters plus a longer word that begins with your 4 letter, and it might make sense to them. Many times they're not going to be able to get their 2 or 3 letter domain name. So it's really just making a list of potential other users. And even if they're not as, say as good or as good as a prospect or a potential user as much as certain ones, still you reach out to some that are on the fringe. So later on, if you ever did receive a UDRP, you could, show that you sent out to numerous companies at the time. We bring that up because acronyms are becoming more and more safe. It really is a defense in a UDRP, but it depends on what the acronym is and how you handled it when you acquired the name. Meaning, if you immediately got it and thought of one company and then contacted them, that's when it looks bad for you. We're going to get to our news now and then get to our cases so we can get out of here in 40 minutes. This would be a great day for someone to run a space, because I know a lot of people like to talk domains, and we're going to be pretty efficient and tight scheduled today. If you want to check out our outline, once again, you can go to dnlshow.com/outline, and you'll see what we have there. I need to add something to that outline, and I'm going to do that pretty fast. But the first thing is congratulations to Domain Gang. Don't need to talk about it. 16 years he's been doing it. If you know Domain Gang, he covers a lot of these UDRPs, has a lot of industry news, and also pokes fun at the industry with some satire. And it's a pretty, a pretty great resource for domain investors. Domaingang.com. Theo over there has been operating so 16 years. Congratulations, Theo. This next little case is only one we're going to touch on in the news, and it is the registrant of WillieNelsonMerch.com agreed to transfer the name after receiving a UDRP. So the domain in question was WillieNelsonMerch.com, and this is a name that we type of name that we discuss a lot in here. So someone has the name of a famous person and adds merch to it, so we understand WillieNelsonMerch.com. And in this case, what they did is the respondent received a UDRP and then sent what they would say is a an informal response to the UDRP. So just send an email back into WIPO, and in this case, the panelist Alan Newberry. I'm sorry, it's Alan Limberry. Um, is was the panelist here, and he's the panelist in our third case today. But Alan said, okay, I'm going to go ahead and consider this person's informal response, and I'm going to rule a transfer since this person wrote in their response that they want to give in. But I thought interesting, I'll go to you first, David, in this one. If you read the informal response in its entirety, it's about 3 or 4 sentences. He doesn't say he's willing to transfer the name. He says he doesn't want to infringe. He sort of alludes to that he'd be willing to resolve this case in any way that seems fit, but he didn't just say, I'm ready to transfer it. Yet Alan said the respondent said he'd transfer it, so I'm transferring it. What did you any comments when you saw this, the highlights of this case and that informal response?
Well, two things. One, if you just want to give up and transfer a name, there's a form to fill out. You sign it, and the other side has to consent to it. And they usually will want to click the box that says without prejudice so that they can go after you if there's any funny games afterwards, like you actually renege on the agreement. But, was he infringing? I have no idea. I didn't look at his website. Could he have used it legitimately in India? Potentially. But I think India is starting to recognize personality rights. So I don't know if they recognize Willie Nelson, but who knows? Jeff, how does it work at the forum? Is there a form that people can fill out and then the transfer can be expedited so it bypasses the panelist?
I don't know if there's a form, but I do know that if the respondent does reply, uh, respond to the complaint in that kind of way, then then the note, then it's up to the complainant actually to point to say, okay, I'm willing to agree to this, but the respondent's got to say these words or has to agree to this, and sometimes that happens outside of what the panel, usually it happens outside what the panelist sees. Other times, like I've done this once or twice, where I've seen the informal response, it doesn't exactly look like a consent, but I'll issue a procedural order to the respondent to ask if that was what was intended, and then send it to the complainant as well, saying, if this is a consent, would you agree to that? And if they do, then then the case could get dismissed, or the panelists. What I've done on once or twice is just take their statement and just do what Alan did, which is write a decision that states, they've consented and therefore there's nothing for us to do.
Response says, please confirm if any additional information or formal submission is required from my side at this stage. I remain committed to cooperating fully to resolve this matter. I think that there is a complete lack of information on the part of somebody who could build a website as to how to respond to the forum or any other entity. There's just no information that's easy to get at.
I don't disagree. The forums used to, remember, both WIPO and the forum are used to dealing with sophisticated, meaning specialists, attorneys, that generally know how to use an arbitration process. This is so different. This UDRP is so different to what their 90% of their arbitration business actually is. So yeah, I mean, I agree with you. It's just not something that comes natural to the arbitration providers.
Great. Absolutely fantastic. Anyway, so WillieNelsonMerch.com was transferred to the, who was, let me see. real fast here. I did want to look at that was Willie Nelson Music Company, WN Music Company, out of Georgia. Uh, just so you guys know, basically the respondent sent in, hey, this is the acknowledged receipt of this written notice saying, hey, I did give this UDRP. I'd like to inform you that all content referenced in the complaint has been removed from the website. I fully respect intellectual property and copyrights, and I have taken immediate corrective action. Kindly note this compliance update in relation to the complaint. Please confirm if any additional information or formal submission is required from my side at this stage. I remain committed to cooperating fully to resolve this matter. Thank you for your understanding. All right, so he didn't say I'm willing to transfer it. He said basically I'm willing to remove him. But I get it. Alan granted the transfer, saying respondent having consented to the transfer of the domain name. All right. Well, he didn't really consent to the transfer. He just said, yeah. I mean, not specifically, but anyway. So I guess he didn't complain. But that's what you get. You send in a note. It's assuming that you're willing to transfer it. The next piece of information, Jeff, I want to ask you. So, Laude last week bought Fairwinds. Now they bought Mark Monitor. Some people thought Mark Monitor would buy Laude, but anyway, so these are three big corporate domain management companies. They manage domains for corporations, and they keep an eye on the corporations. Well, tell us the several things that they do, like what Laude and what Mark Monitor does for a corporate client.
Yeah, sure. And Fairwinds is a little bit different. Fairwinds was never a corporate registrar. They advised corporations on their portfolios and what they should do, but Fairwinds was not an ICANN accredited registrar, at least not for most of their customers. So the combination with Cum Laude now attaches an actual registrar to the work that they've done. So that's kind of the benefit from that Fairwinds gets from Cum Laude, and of course Fairwinds has a lot of American large or international companies as well. So it really brings a good customer base. Now Mark Monitor was one of the two largest corporate registrars. They've been bought and sold so many times since their original founding in Boise, Idaho. So this is the latest, and I think probably the last sale of Mark Monitor to Cum Laude. So I think they finally now have ended up where they should. So I see this as a combination of two of the top three corporate registrars that are out there, which that should make it the number one corporate registrar, the largest corporate registrar out there. So what they do, obviously, is they maintain the domain name portfolios. They advise the customers on what names to get, what names to keep, new TLDs. They'll represent some of these brands if they apply for new TLDs. They'll take care of basically provide the white glove service that these large corporations need because they're not a lot of them are not used to going into portals and registering names themselves. They're used to picking up the phone and calling people. And so they'll call these registrars that provide that kind of service. So, corporate registrars, they charge a little bit more per registration than, the likes of, I was going to say GoDaddy, but GoDaddy now just doubles the price, the wholesale price. But certainly they're more expensive than Namecheap or Pork Bun. But that's to pay for your 24/7 account manager and service that you get.
Okay, before we move on. So anyway, what was important here is so Cum Laude and Mark Monitor also assist a lot of these brands and companies to apply for and operate their extension, their string, and in some cases, Jeff, was Cum Laude or Mark Monitor? How much do they offer once they help a company apply for a string and successfully get it? Are they RSPs themselves, both of them, and do they manage registries themselves?
So at this point, they're not RSPs at all, but they'll do kind of all the front end stuff that consultants would do. They'll do a lot of the stuff, Todd, that you and I do, but they generally will only do it for brands, and they're not business specialists in how to sell domain names or marketing plans or things like that. They really are for corporations that either just have it defensively or that already have their own strategy as to how they're going to use it. They're not going to get that kind of advice generally from the corporate registrars.
Okay, let me make a few announcements. Then we got one quick topic that a friend of the show, Summit, brought to my attention about the domain vinyl.com. So stay with us. That I want to make a couple announcements, and then we'll talk about vinyl real quick, and then our 3 cases today. Well, we'll get through those pretty quick. My announcements are, as Jeff just mentioned. Okay, so Laude and Mark Monitor, now they're one company. They're big, and they normally help the big brands, some big companies, manage their portfolios. They also help companies apply for the new GTLD and ICANN's next round. Well, we're thrilled because as it's almost like competing, we're actually competing, but they're a big company, multi-million dollar, maybe even together, billion-dollar company now. And they have a lot more overhead than we have. It's like basically big sponsors, but we're both running in the same race. So Jeff and I have formed a company, TLD Strategies, that a lot of you know about. We're helping companies, in different entities, and some individuals apply for a string of their choice in ICANN's next round for a new GTLD. We offer full package of services. If you're interested, just go to tldstrategies.com. There's a lot of it's heating up. It's pretty fantastic. Everybody's, a lot of people that are interested in applying have a lot of questions and want to know what's the difference between what we do at TLD Strategies and what some of the bigger companies do. And there's lots of other consultants out there that you might cross paths with if you're interested in this area of domaining, and would be really operating a registry, applying for a new GTLD, and then, as I say, the work begins from there. If you're lucky enough to be successful in getting a string or multiple, then it's time to run the business. So certainly reach out to us at tldstrategies.com and set an appointment, and we'll tell you about what we can do to help if you're interested in, like I said, this area of business. Also on the outline, I have, are you interested in being part of a TLD fund? If you are, there's a link on our outline at dnlshow.com. You can just go to tld.fund or tldfund.com. You don't have to go to the outline, but I do have a link on our outline. And then you can input, yes, I'm interested. Here's my information. And in October, I'll be reaching out to new folks that have interest, because I've already had several colleagues and people in the business say, yeah, we'd like to apply for a string, but wouldn't like to take it on completely ourselves. Is there a way we can be part of it? And so that's why I'm establishing, or really looking at indications of interest in who would want to be part of a fund. What can they bring to the table besides capital, because it would take some investment, but also what experience do you have and what can you bring to the table? If you're a registrar, or if you're a marketer, or if you have registry experience. Basically, there's everybody's unique. Everybody has different things they bring to the table. So if you are interested in being part of a TLD fund, that is owning a string with a group of others and then eventually operating a registry, reach out. You can go to tldfund.com and just fill out the contact form. Okay, the final announcement was, I've been doing this every week. There's links on our outline, dnlshow.com/outline. Thanks to the people listening on replay. We are on Spotify now. You can listen on Spotify, you can listen on YouTube, or you can listen to a replay here on X. But for the next couple months, there's a nomination process for the Lonnie Borck Memorial Award, and my recommendation is that we nominate Jeffrey Neuman, our co-host here. I think he's more deserving than even some of the past recipients, and there's some really, great recipients of this award. But Lonnie Borck was a domain investor, very well liked, great guy in the space, and they've honored him by offering this award each year. The ICA has. So please ask that you go to our outline, dnlshow.com/outline. You can see where you can nominate Jeff. And then they also offer, or they're also giving out an award called the Trailblazer Award. And I suggest Chad Folkening is the Trailblazer in this space. So just wanted to say that. Thanks for taking a look. I'm going to say that every week because it's on our outline and until the nomination period closes. And then they'll award that in January at the ICA annual meetup. Thanks for listening on that. The topic I want to bring up before we get to our cases, and we're going to get to these really fast, is vinyl.com. There's a company, Vinyl Group. They've been using the name vinyl.com as their online, record store, basically. They sell vinyl there. Well, Sam asked a good question. I was thinking, is vinyl something like spandex, where it's a unique type of somebody invented it and somebody owns it? But no, I see it's just a type of plastic. It is generic. So, David, I want to first ask you, this company, Vinyl Group, apparently one of their employees owned vinyl.com for years. They've always used it, but it was owned by an employee. Now they're acquiring the domain name, but they have a trademark, vinyl.com, to sell vinyl records. How can they have a trademark on such a generic name, or is it really limited, sort of like the booking.com, mark, so on? So please explain, how can they have a trademark on vinyl.com to sell vinyl records?
Yeah, that's a funny one. Well, I'm just looking at the trademarks for stamps.com. I noticed that originally stamps.com Inc. applied for a bunch of marks and they were rejected out of hand back in the 90s. And then later on, somehow they got registration. They got the first one and they got a whole bunch of piggyback ones. It's a very narrow scope. So it's the same kind of analogy as in the booking.com decision. And what we'll see in a few minutes about the stamps.ai decision, but that's how it is. So vinyl.com does not necessarily imply that it's records. It could be actual vinyl. It could be all kinds of things. So what is the registration for? Let's see. Vinyl, I can spell. So there's two trademark applications that were refused. One is by William Douglas, and the other one's by Tony Ventures. So where is this registration you're talking about for
Yeah,
vinyl.com?
I'm not seeing it.
Maybe they planned on applying, and you got me thinking, David. So they could apply and say they want to do it in the music space, vinyl record products, because right, it could be vinyl curtains, vinyl siding, vinyl flooring. They could be selling different types of vinyl, but still, even if they specifically wanted to apply for vinyl records by using the word vinyl, it still would it likely go into the supplemental? I mean, they can use it. They can use the name. It's just not going to be anything they can protect, and that would likely go into the supplemental registry.
Yeah, that's right. Supplemental register is the typical route for this kind of name.
Okay, I think we'll make some things clear here when we get to the stamps.ai case, but we'll look more closely at that too. And there's just news coming out that this Vinyl Group has, they've been using the domain name, but now they're acquiring it, and I'll look more closely at that to see if they planned on, what their plans were with regards to trademark, what category. I think they already have something, but you guys say you didn't see it. Well, let's get to our first case because we're going to get out of here in 20 minutes. Stamps.ai is our first domain name. So there's a company, Accutane LLC, was the complainant in this case. They're out of DC, and the registrant was Brett Bloom out of Florida. Well, I'm a stamps.com customer. Basically, this complainant is a global shipping and logistics company. It operates stamps.com. It has 4 million customers at stamps.com. I thought it was even bigger than that, frankly. But they've been operating their company since 2003. So they've been around for a while. But anyway, so stamps.com, you go there and you can, of course, just buy postage and you can print out your stamp, and it's for USPS, the postal United States Postal Service. And I don't know, they make money off of, maybe is it a monthly that we pay? I can't even remember what we pay, but you usually just buy, you buy $10, $25 worth of stamps, and you can use it. So I don't know how they monetize exactly. Maybe there's a small fee, but I recall only paying, what the postage is, and it's no more than doing it at USPS.com. But anyway, so this company operates stamps.com. They have a trademark for stamps.com. They have a trademark for stamps.com and even stamps.com online. But the complainant was saying at the time, I guess there was nobody contested their trademark, so now it's legally incontestable. And the respondent did answer in this case and said, my plan was to offer a service where it's about stamp collecting, not offering postage as stamps.com does. And I got stamps.ai because of what I wanted to do, a legitimate business that doesn't compete with their business. So I don't believe that they should be able to take stamps, dot AI away from me. There's a little bit more to it. David, why don't you go first, and then Jeff, you can comment on this case and then give us the decision. Go ahead, David.
So situations like this, where you have a trademark registration for a common word like stamps.com, and you're filing a UDRP complaint against stamps.ai, the owner of stamps.ai now has a cause of action, now has standing to go to the T-tab and petition to cancel its stamps.com trademarks, even though they're incontestable, on the basis that that they've abused their market position and they violated antitrust laws. So there's a Sherman Act Section 2 that they violated by filing this complaint against stamps.ai. And so now they're vulnerable. If they were to appeal this case and take it to the next level, go to a federal court, that would be a counterclaim to cancel the trademark based upon the Sherman Act violation. So that's a good thing. Now, in terms of the domain usage, right now the lander is on only domains. So it looks like I don't know what kind of platform only domains is, but you can search for their names there. I'm not seeing any other, but they offer business email, web hosting, and more domain names. So I don't know who owns it, but only domains seems to be the platform.
So look, stamps.com, they have a trademark in stamps.com, not stamps, just stamps.com. And they use it in a trademark manner. I don't think at this point that any motion to cancel the trademark or any filings is going to result in the loss of that trademark. I don't think stamps.com as a whole mark is generic or descriptive, which is why this case kind of came out the way it did, right? To this case, they basically said, your mark is not stamps, but stamps.com, and the name that you are going after is stamps.ai, meaning you are claiming rights to the word stamps, which you do not have. And at the end of the day, they said that the respondent does have a legitimate interest in having a generic or descriptive term, and that there's no bad faith. And so at the end of the day, the respondent won because of the mark itself, which is stamps.com. Now it's interesting. I don't think they, and I have to remember, they didn't put a finding in for whether the mark is confusingly similar to, or sorry, whether the domain name is confusingly similar to the mark. They kind of punt on that. They just punt to the second element. I would have liked to have seen the decision say that it's not confusingly similar because the mark stamps.com is not the same as stamps dot or as just the word stamps. And but they didn't. They just went to the legitimate rights and interests, and the respondent succeeded.
Yeah, the respondent here, lucky, obviously worked out in their favor. The complaint was denied. The domain owner gets to keep his name. But as the domain owner, you'd like for them to have ruled that no, this company doesn't have standing to file this case, meaning they don't have. It's not confusingly similar. But they basically didn't even rule, Jeff. Patty Tam, Paddy Tam, was the single panelist on this case, and basically said, well, it's not, you don't have rights to stamps. You have rights to stamps.com, and this is stamps AI. So from what they put in the decision, from their summary, it seems like they would have said, so you don't have, this isn't confusingly similar. You don't really have, a trademark for stamps. So no, it should have probably, been resolved right then. Like, no, you didn't
But
successfully
see,
show the first element.
trademark attorneys that are panelists don't like to do that because they don't want that setting a precedent in a trademark infringement action to say that they're not or they can't be confusingly similar. Um, and that's why you will rarely find a trademark attorney that works with brands ever finding something is not confusingly similar, even though they know it's not confusingly similar under the UDRP's definition of confusingly similar. But they'll never put that in writing.
I see. And right, they're basically saying, so the complainant has the rights to stamps.com. Their trademark is stamps.com and stamps.com and so on. But there is somebody that could make a case and say, well, stamps is what's to the left of the dot in their trademark, because they do have a trademark for stamps.com, and then it's the same to the left of the dot in this domain name. And so that's where they could say, somebody could say it is confusing because there's only one word before the dot, stamps. But then again, you can't trademark that generic name. Okay, so anyway, the panelist says, you know, you don't own rights to stamps, but I'm still going to go into the second element. And yes, this guy does have rights. He can do a stamp collection service or software, something using AI on stamps.ai. So we're going to, say that you weren't successful. The complainant wasn't successful in element 2, and then so didn't even rule on element 3, and said, we don't need to say whether it was registered in bad faith because we already showed that he does have legitimate interest. So the complaint was denied. This next case, I put it in here, and I know, David, you saw this. Why would Todd put this case in here? Well, because a couple weeks ago, Ragu asked, put in a case that's an obvious trademark infringement. He sort of said that, but basically a case that's not really questionable. The next case is help-salesforce.com, helpcenter-salesforce.com. So I just mentioned these two domains, help-salesforce.com and helpcenter-salesforce.com. They were both registered June 23rd of this year, 2025, and the second one, June 30th. So both within a week. Salesforce is the complainant in this case versus this Tai Hong out of California, this domain. I don't know. Are they an investor or are they just some infringer or somebody trying to, really almost criminal what they did? Because Salesforce, the big company, been around since '99, filed this case because they said, hey, these domains are resolving to web pages that are mimicking us. They're showing, our trademark, our logo. The complainant was so upset about it, Salesforce contacted the hosting company and successfully, requested that the hosting company shut down the sites. That's what we call the DMCA takedown, because they're saying, hey, they got some of our copyrighted material on their website. We ask that you take it down, and they, you have to show a little bit of evidence that you are the copyright owner. But anyway, so they did that. The websites were taken down. The respondent did not reply to this UDRP complaint. Well, it's pretty easy for Linda Bryan, the sole panelist, said this is a classic case of cyber squatting. They registered these names well after the trademark. They are using the the complainants trademark their name Salesforce right in it. They're using it with words help hyphen Salesforce. Very confusing. They're on the website. They were being confusing using their logos and their trademarks. This is a classic case of when someone this is a lot of names in parking companies that parking companies make money off of similar type names, and you think, well, these reputable parking companies should know not to accept these type of names, and some of them don't. But this is a exact example of cyber squatting. And this is, so Linda Bryan said, we're going to transfer this. Salesforce has rights. This domain owner, registrant, had no legitimate use to it and registered it in bad faith, pretty clear, and then didn't respond. So that's about as clear cut as you can get. What comments did you have, David, when you saw this? Did you think, it goes exactly as it should, and shut the books on it?
Yeah, I was looking at the decision, and it was kind of strange because the respondent is Meta Platforms. And so immediately I thought, okay, let's look at the who is. And so I go to the who is, and it shows up as private who is, email Cosmotown. And both these domain names were registered recently. They're using Cosmotown as a registrar and Cloudflare as the name servers. Now, that doesn't jive with what Meta Platforms would do. So obviously it's an impersonation. So the respondent is named as Meta Platforms, and they actually mentioned somebody's name there. I don't know if that person is an employee. Tai Hoang, does he actually work for Meta Platforms, or is this the actual registrant? There was no response because probably they didn't get the email. Now, this is the kind of case that they talked about at Domain Summit earlier this summer. Dave Barnett talked about domain names used in brand infringements, and the hyphenated names with Help Center or careers or anything like that, plus a brand, are typically used for phishing sites. And somehow, like, you'll get an email that says click here, and you think you're going to the actual Salesforce website, for example, but you're not, and you're being fished into giving up your information or something going on. So yeah, they download the zone files. They scour the web, the zone files for these kind of domain names, and they categorize them by IP address, hosting company, um, registrar, and they kind of try to figure out, okay, which domain name should we go after the most. So yeah, this one seems like a phishing attempt, and I'm not surprised by the transfer order.
Anything surprised you here, Jeff?
No, this is a run-of-the-mill routine case. That is a good example of 90% of the cases that are filed. So no, I think this case is pretty open and shut.
Yeah, we'll get to our next case and then let Jeff comment, and then he can take off, and we're all going to take off about that time. I want to make sure he gets a chance. This last case, niagen.com, plus the .org, the .online, the .club. So this company, Chromadex, filed this UDRP against the domain name niagen.com. Now keep in mind, niagen was registered in 2011. The .org, .online, and .club were registered in 2017. I bring that up because Chromadex files this lawsuit against, or this UDRP, versus a couple different names, Angelina Nia and Angelina Leo. Basically, the respondent, the domain owner, used a couple different names, but the complainant did show that all the names were controlled by the same person or the same entity. Long story short is, the complainant, big global bioscience company, and they came up with this product, some nutritional supplement called Niagen, and the complainant and her husband had reached out to Niagen, to this company, and said, hey, in 2016, right when they came out with this product, and said, hey, we'd like to build some business relationship with you, and if you don't want to, well, we'd even sell you the name. But they quoted him a $250,000 price. Now, This is all coming from the complainant because in this case, the respondent didn't reply. Jeff, tell us a little bit about this case and the single member panels, Alan Limbury, why he ruled the way he did.
Yeah, so this really Alan takes it well at the end essentially divides it up into two different classes of names. First is the niagen.com mark, right? That was registered in 2011, and that was before the complainant had trademark rights. So that one was analyzed in a different way than the other four names or three names. Sorry, the other three names, which were all registered after the complainant had trademark rights. So with respect to the first one, niagen.com, the panelists said, well, this was registered prior to the complainant getting rights. And even if the complainant the respondent is using that name in bad faith, we have a conjunctive requirement in the UDRP that has to both be registered and used in bad faith, not registered in good faith and then subsequently used in bad faith. That doesn't um, succeed in a UDRP. So with respect to that name, Alan said, look, that name, they couldn't have registered it with you in mind, the complainant, because you didn't exist or your rights didn't exist. So therefore, with niagen.com, that stays, that does not get transferred, even if I think the use is not a legitimate use. The second class of names, the other three names were all registered, like I said, after after the complainant got their rights, and specifically were registered because or with the complainant in mind because they wanted to do this deal. So in that case, for these three other names, the panelists found that these were registered in bad faith and then used in bad faith by offering them for sale for a 250,000, which of course well exceeds their out-of-pocket costs, and strictly only have that value because of the goodwill of the complainant. Um, they pretty much admitted that by saying we registered it so we could do this deal with you. So there you go. Three names were ordered to be transferred, and one name, the important name, niagen.com, it just stays where it is, and respondent prevailed.
Great. Thanks for your comments on that, Jeff. I know you're taking off, so have a good rest of the day. David and I'll wrap it up from here.
Thanks, everyone.
Yep. See you next week,
Thanks,
Jeff.
Jeff.
So, David, this case, it was, interesting that the respondent did not reply at all. And I would think, geez, it really run the risk of losing that .com. But Alan said there couldn't have been a bad faith registration. They had it before, before you were, the product that you created even existed. But yet Alan was certain that this domain owner of those other names was aware of the company because they had contacted them. So why would they have registered the .org, .online, and .club? Is there any reasonable defense they could have had for those other three names?
If they were actually using it for something else, they could have used a tacking defense because their prior rights tack on to the futurely registered domain names from the .com to the other ones. But in this case, there is no actual use that I can see. So that's odd. Now, it's interesting that this name was registered before the current registrar got it. And it's registered in 2005. It looks like it dropped in 2008. It looked like it was parked at some domain seller before, potentially, because they have those typical old style links for a landing page. Yeah, so it's hard to say what the history of this name is, other than yeah, the current registrant has it at GoDaddy, and the registration date is 2011. So therefore, there's no bad faith. But the other ones, yeah, it could be good faith, but not in this situation.
with no defense. So David's absolutely right here. And we talked about niagen.com was registered in 2011. He said even before that, but then registered by this respondent in 2011. This product wasn't created till 2015, 2016 timeframe. And at that point, I said the domain owner and her husband went to this company and said, "Hey, you want to, partner the nutritional supplement." I don't know what experience they had in that area of business and why they wanted to do that. Um, that's interesting in itself to say, okay, so we see this company's offering this product and we own the domain name. Not, it's not impossible and not uncommon actually for you registered a name 20 years ago. Somebody finally has a product with that name. In something like this 6-letter NIAGEN, obviously possible, and in fact did happen. In her registration, she had Angelina Nia. Almost, is it part of her name? Was it her last name? Was this made up? And David, I agree. You touched on how they could have said, "Hey, do you want to partner with us? We'd like to do some business with you. We own this. We happen to own the domain name Niagen." And the company says no, and they said, "All right, then we're going to offer, crochet equipment, and so we're going to go in a completely different direction with the name. But thanks, we thought you might have some interest since you're a big company and you spent all your money branding a product under this name. All right, then we'll go our own way." Then if they said, in an email to them, then we're going to go and offer, generators or just something different, then registered these other domain names, .org, .online, and .club, then they would have needed to answer the response, this UDRP, and include all that. And then maybe Alan would have said, yeah, they registered niagen.com way before. There's no bad faith. These other ones, if they use them in coordination with that domain name for this, other area of business that they said, may have been able to keep it. But anyway, I'm happy they got to keep the name that they registered beforehand. He said, boy, you sure want to answer. And I say you sure want to answer, but then again, sometimes people put their foot in their mouth and might say something that could actually have got this name transferred away. So next time, if I have a chance to speak with Alan about this, say, is there could an answer have been? Could they have answered in some way that could have made it worse for them? Sure, I guess it's possible. Well, all right.
So with this name, what this domain owner should do is create a website selling those creek generators. So there are people who live by creeks, and like NIA stands for like Niagara Falls, and Gen stands for generator. So you could actually be generating electricity using a river or a creek on the edge of your property, especially if you're living remote or off the grid. So that would be a great usage for this name, Niagen.
Yeah, now that you say that too, I mean, Niagara Falls, but I mean generating energy from stuff like that. It's a cool name, but a lot of these brandable names, companies now have formed. The domain was registered prior, but they're coming after it just like this. What this complainant tried to do is confuse a little bit and thought, this is great that they contacted us, offered it for $250,000, and then registered 3 of the names, because the complainant tried to say there's no doubt they knew about us when they registered these 3. They're all controlled by the same person, so let's get them. And the panelists slowed things down here and said, I know you want them all, and it doesn't look great for those subsequent registrations, but you can't get their first one. They didn't know about you. You didn't show any evidence that they knew about you. They couldn't have. You weren't even, doing that product. So, right, Jeff said it. Yeah, Alan said complaint denied for the .com, but for the .org, .online, and .club, those are all transfers. So, thanks for being here. And once again, you can listen on replay on Spotify. I'll get it on Apple here. Apple was having some problems with their Apple Connect for broadcasters. So I'll get that squared away. But if you're dying to listen to domain name law, you can listen to the replay right here on X. You don't have to have an X account, or you can listen on YouTube. Everybody, you don't have to have a YouTube account. You can just go to YouTube and search domain name law. But okay, so we're on Spotify. Congratulations. and you can listen to it there. On this Thursday, Josh and I are going to be, broadcasting DNX show. That's at 10 a.m. Pacific, 1 p.m. Eastern. We go for 2 hours there. The following week on the DNX show, we're going to have Monty, Con, and Scott from Right of the Dot. They're performing, and they're right in the middle of an auction right now that's on using the GMB platform. That's where you bid, and if you're not the winning bidder, you actually can make money from the winning bid. You get compensated for bidding. And then they're going to talk about their Dubai Days auction, but then most importantly, they're going to tell us what's going on with the NamesCon auction, some of the featured names there, and if there's a way for some domain investors in the community to get their names listed as part of the live auction that they have every year with Wayne Weed, who's a professional auctioneer. They do it live at NamesCon, and this year it's Wednesday afternoon, November 5th, after I get done skewing the whole industry. But anyway, so that's October 9th. Monty and Scott will be there. This coming week, we're going to be talking about dropping names out of your portfolio. It's tough to drop names. When is the time? And, you can't just always buy, but never, you could never drop names. But we're going to be talking about Josh's strategies when it comes to it and what I've done dropping names over the last several years. And then we're also going to be talking about the risks of building on and investing in CCTLDs. Some people consider not much risk at all, and they don't even consider it. But there are risks of both, building your company on a CCTLD and investing in them. And then I know Afternic came out today with their top keywords, and we're going to touch on that because domainers love to know. Josh was talking about intelligence as a keyword. Of course, people heard him talk about investing in domains that contain the word finance, but he likes the word intelligence. Well, that's not a long word, is it? Intelligence. But he likes that. And I saw intelligence.xyz sold by Swetha for $150K. It looks like it was in the last week. But Afternic released their top keywords in domain sales, and AI was number 1 in July. My was number 2, home, and it looks like group. Anyway, we'll go through them on Thursday. So if you can join us then, Josh and I'd appreciate that. It's an open discussion, so you want to come and you want to talk, not just listen. Please bring your thoughts, bring your comments, bring your questions. So that's Thursday. We appreciate everybody being here. That's going to do it for the Domain Name Law Show today. David, Jeff, and I will see you next Tuesday at noon Pacific, 3 p.m. Eastern on Tuesday here for the Domain Name Law Show. Thanks for joining us. Enjoy your day, the rest of your day, wherever you're at. Thank you.